got so motherfucking design on right now. Bring it down, bring it down, bring it down. I got 3 old thoughts on the block.
But how you doing, bro? How you doing? Mark, how are you?
You're leaving now?
This is a discovery now. I think. The state, I believe, is not.
Judge, this is an old colleague of mine, Mark Lambert. He represents one of the banks that Bruce Cobb has tried to subpoena records from.
Colleague
Yes.
of yours?
I don't know if that's a comment on me personally or.
He's he looks fairly young, Your Honor.
Well, when y'all stand close to each other, yes. He does. Hey, Bruce, a couple of things here that jumps out at me. As you know, this thing's 4 years old.
Right.
It's too old. We got to move forward.
Right.
So how are we going to do that?
I'd like to get that discovery so I can defend this case.
Well,
what's
okay, so let me respond to that, Judge. If his contention is that he's going to utilize this discovery to defend this case, that is absolutely ludicrous. That it's the amount of loss is not even an issue in the indictment. There is no complainant listed in the indictment. That'll be his next thing he points out, which is that the complainant really recently passed away. So if this discovery is designed to determine the restitution and he wants to resolve this case, then yes, I'm for it. But the amount of loss simply isn't an issue. And I've always agreed to a limited version of producing this discovery under the assumption that he was trying to get it to make arguments about what the restitution should be.
Well,
But if he-
but it's a lot more than that.
It absolutely is not, actually.
To the fraud is an essential element.
Okay, well, how does that amount of loss have anything to do with intent to defraud? One shred of
In
evidence.
this case.
Okay, well,
But you know, it should be very relevant to the amount of restitution, if it is.
which is not something the jury even determines.
All right, y'all through? What is it everybody wants?
Okay, Judge Mark Lambert, I'm your Purdue Good Credit Union. I guess I'm the point of contention here. At this point, we've received a subpoena. We've objected to the subpoena for the records that Mr. Cobb are referencing. Under section 59 of the Finance Code, the only possible way I can produce these records for Mr. Coon, whose records are being sought, is if he is served with notice and has the opportunity to object and signs a waiver. Otherwise, the financial institution can be held responsible for releasing privileged and private information and offered information. Obviously, that didn't happen. He's now passed away. The only other opportunity for Mr. Cobb and Mr. Eckert to get these records, if the court so desires and grants, is if the court will sign an order for us to provide the records to the judge for an in-camera inspection to determine the scope of the records that would be either admissible or discoverable and any redactions therefore. I don't think I can technically redact until the court says these are the records we have to produce. So we have a subpoena sitting on us that is due. I have objections that I filed with the court. I just don't know the scope of what the court will require me to produce to the party.
What do y'all say about what the gentleman just said?
Well, Mr. Kuhn was supposed to have gone and done a waiver, which we had agreed that he would sign, but he never got around to signing it because he passed away in the process. That'd be a lot better than for.
We know he's passed away. What are we going to do about it? We can't change that. We move forward and
Right.
we're moving forward one way or the other.
Yeah.
The passing away of an important person involved in a lawsuit doesn't scuttle what the grand jury has indicted. So we get forward.
Judge, I think you need to order the bank to give you the
Yeah,
records in camera.
Yeah.
That seems to me the proper way that this court has control over the situation, and all the parties are placing it into the hands of the court in these pretrial matters, which I think is where it needs to be. And when there's a disagreement of the way things should be. What I want from the bank is a proposed order, please, that
Probably has one.
fits with what you deem under the law is the way to proceed, that also is in the best interest of your client's liability exposure. And I can appreciate, my dad was a battler, so I will appreciate and the caution. But this is 4 years old.
We should have-
It's way, way too old.
We had worked on an order. And I think,
I have a motion to compel discovery here back in January, from January, and then an order granting a protective order here. This was this presented by?
I think it was a mutual document drafted by Mr. Cobb and I initially, to protect us until he could get the waiver signed by Mr. Coon. And I think at the end of that order, if I remember correctly, is the section 59. And it sets forth the documents that he wanted and that we would be protected.
Have you seen this?
I believe I have.
Any
to.
objections for me signing this?
What's the scope of what's to be produced?
it's that same thing that I mentioned.
Well, Bruce, you
When you do it, it bothers him.
yeah, because it's way broader than what we talk about.
He's always grabbing for his wallet when you're near him, Bruce, for some reason.
And just so we're on the same page, Your Honor, we're talking about a lot of records. They haven't been sifted through by the bank because we didn't know the scope. So I can narrow it down to whatever scope that the work orders or the parts will be on. I just need some guidance.
Yes, this number 2 here is the scope of what I've agreed to obtain for them.
I've got both Mr. Coker and Mr. Cobb's signature on this.
Sure.
Okay, that will be made a part of the record, and we have a defendant's motion to compel discovery and request for hearing this.
Well, I think
What
that's
else?
moved.
Go ahead. It's moot.
We already had
You
that.
withdraw this then?
Yes.
Okay, then. So what's next on this 4.5-year-old case to move it forward? What do we?
They're going
what
to
do I need to do?
they're going to submit an order.
Okay.
Yeah.
All right. Well,
They've yet to
that
tell
may or
me.
may not work, depending upon what's going to be necessary for preparation, but it'll stay there on that docket, and it'll be at least a goal for us to reach.
Right.
To try to reach. What else do we need to do today that you need from me?
I think that's about it, Your Honor.
Okay. From state, how many witnesses are you guessing you're thinking about? And maybe
5 to 10.
Okay.
5 to 10.
All right. Anything else?
No, thank you very much.
Then we'll see you back in August, I guess. Try to do what you can to be ready.
Right. And the documents will be submitted to the court, and you'll send them up the river.
Absolutely. We'll submit an order to Mr. Records, Mr. Cobb, and have that to him this afternoon. I can have the records to him next or to you, Judge, next week.
While we got this,
Yes.
so I'm not in the dark.
Uh-huh.
That's because I don't know, I don't know anything about the facts of this case. I can look at the probable cause and that's all I can see. What is it that each of the parties are asking me to be wary of and to pay attention to?
Well, for one thing, I think they're going to have his co-defendant testify, and I'm going to have to
I'm
probably
talking about the records.
the records
Yeah, I'm not talking about that. I'm talking about the records.
outside of the
God.
proper deduction.
That I'm going to get a bunch of records here,
Yeah.
and I want to be able to sift through what's relevant for me to look
Right.
at and what I don't need to spend the time looking at.
Well,
What's the defense?
part of the thing that we are contending is that this was a normal construction. Somehow this was a construction case that went awry. And the complaining witnesses stopped the work, which is rare. The normal case would be like a roofer. When you give $20,000 to a roofer and he starts to work on it and he doesn't complete the job and runs off. This isn't the case at all. These people worked on the job until fired. They were fired by the Coons, and for some reason, the Coons also sold it, did a sub sale, and also had debt forgiven by the do-good. And what this does is it pretty much cleans it up. There was no intent to defraud ever.
I'm not asking for your final argument. I'm just asking for what is it that I need to be paying attention
Well,
to?
that-
Your
okay.
view in these gigantic
I need to
records.
find out if the Coons ever put some money up front that was never.
In the records.
In the records.
What is it
Right.
in the records I need to be looking at?
Well, that's just partly it, but the thing about it is how the do-good controlled the draws and gave the money to Mr. Coon. And Mr. Coon was the one that gave it to the co-defendant. And then the co-defendant actually had him, supervise the work on the job.
Okay.
That's what it is. This should have been a civil case. And Your Honor, there's one other
Okay,
thing.
it, the grand jury thought otherwise. That's the way it
I don't
is.
think the grand jury ever saw that there was a $1 million.
You were in the grand jury
negligence
room.
problem.
That would have been an illegal act.
No, I
You don't
wouldn't have
know, Bruce. Can't talk for them.
Even
And
so.
you trust that they're going to abide by their oaths. And until you tell me otherwise, don't badmouth the grand jury.
No, Your Honor, but this is a
Don't
complicated
criticize the
case.
way that this is done unless you have something to say about that's articulated. They came up with an indictment, and I know grand juries from my experience, they don't dream it up. And it's probable cause. This is beyond a reasonable doubt. That's the big difference. But don't be arguing, a grand jury indictment. It's there. So we're dealing with it and we got to move forward with it. That's a waste of time. And unless you can say that the grand jury did something wrong, which I've never had that presented to me in 44 years. Okay, from state.
I would urge you to go through the redactions with a heavy hand because it is virtually pointless. What he's describing is nothing that is relevant to this indictment of whether or not this man misapplied trust funds. The only reason I've even agreed to this is because it's taken him a year and a half to get this.
Okay, we're fast tracking. You got my attention, which is going to move this case forward. From the third part.
How would you like them? I can do them in paper form, digital, zip drive, whatever the court prefers, and it's easiest for you to review. And representation.
Well, everybody's going to get a copy of this.
Once you've had just like with CPS records, Judge, you have to decide what is redacted first. And I will say for the record that typically when CPS like this, CPS often produces records in camera like this for this court to review. They submit proposed redactions
Okay.
with their records. I understand that may take you longer. However, that often is what the court looks at and relies on.
Okay.
Just so you know.
Well, I guess hard copy is easy to. Nowadays, I really don't know. I'm just used to hard copies.
You're talking about thousands of pages, though.
Judge, how about I do both? Hard copy and a zip drive. Would that
Okay.
be easier?
Yeah, because I can pass on those to the parties. It's easier without getting a pickup truck. Okay, let's see what we can do quickly, and then we've got an August trial date.
Thank you, Judge.